Okay, we're live.
Thank you. Seventh Court of Appeals wants to welcome you to the March 3rd, 2021 afternoon settings. And we had two cases for this afternoon, and one settled. They had an agreement, and it involved a comedy movie star that you've probably known or heard of, but we won't be involved in that one anymore. We'll go on and call the docket. Sitting on the panel today, of course, is Justice Parker and then Justice Doss and myself, Brian Quinn. We'll go on and call the docket. We will presume that since you are appearing via Zoom, and again, thank you for appearing via Zoom, that you are ready to present your arguments. So I would dispense with asking you to make an announcement. So we'll just go on and proceed. The first case, well, the only case we have this afternoon is 07-20-00284-CV. Now, I've already been corrected on this once, haven't I, Miss Justice Doss?
That's right.
I called the city of Buda, and I'm told no, I was wrong. So I'll say the city of Buda or Buda versus NM Edificios LLC. And Mr. Hyde, I guess you're ready, correct?
Yes, Your Honor.
And how do you pronounce it?
Well, I'm the city attorney for the city of Buda, but I'm sure that if you say Buda, it's my hearing that is off, not your pronunciation.
Very good. I like that attitude. Ms. Hatchett, for the appellant, appellate, excuse me, you ready to proceed?
Yes, Your Honor.
And how do you pronounce it?
I also pronounce it Buda, which I was told, I also pronounced it incorrectly when I moved to Austin, and I was told Buda.
Yeah. How do you pronounce M-I-A-M-I?
What? I'm sorry?
How do you pronounce M-I-A-M-I? It's a city in Florida and Texas.
Is that Miami?
Well, in Texas, it's Miami.
Oh, okay.
Okay.
Spelling was stressing me out, so not my forte.
I understand. With that, Mr. Hyde?
Yes, sir. Do I need to reserve the 5 minutes, or is that automatic?
That's automatic. Yeah, 5-minute rebuttal.
Thank you, Your Honor.
Whenever you're ready.
May it please the court. The city of Buda is the first city outside of Austin as you head south towards San Antonio on IH-35. It's one of the fastest growing small cities in Texas, and it's reported since 2010 it had a population of 7,500, and estimates today that it has a population of over 20,000. The property in question sits along West Goforth Road. Its court record 36 will show you that it's sandwiched on 3 sides by residential subdivisions and connected to Bradfield Village Park. The easement in question generally follows the course of the natural tributary, bisecting the property diagonally. Bradfield Village Park, during severe weather, doubles as a drainage feature and includes a spillway and detention ponds to regulate stormwater as it travels through to Onion Creek and outside the city limits. The appellee is seeking this court to judicially legislate that non-regulatory provisions within a development agreement, including the consideration for the agreement itself, are somehow transposed into land use development regulations under 245 and then are imposed on the developer. And we consider that argument novel at best. On page 21 of the appellee's brief, it represents to this court that the Chapter 245 waives governmental immunity for declaratory, injunctive, and mandamus relief related to certain vested rights, and quotes, the effect of vested rights under Chapter 245 of the Local Government Code is to freeze the land use regulations as they existed at the time of the first permit application was filed. And we don't contest that that's what 245 does.
Mr. Hyde, may I
yes, sir.
Interject or ask a question? Read the briefs. It's been a bit since I've read them. Clarify for me in a nutshell, what is this dispute about?
It's the property is sitting in a FEMA floodplain, and it has to be significantly filled in order to get up over the floodplain. And the dispute is whose obligation was it or is it to make this make this drainage issue meet the additional floodplain requirements.
And there's a developer, I guess, that wants to make this a business area, and the dispute is who's supposed to pay for that. The additional improvement to the property so that it could be developed outside the floodplain. Okay, thank you.
Yes, sir. So, you know, in the briefs and in the pleadings, the appellee has not identified any specific land use regulation that has been imposed on the developer that was not required at the time the development was entered into, because there is none. They try to transform good faith attempts taken by me as city attorney to resolve a conflict without the need of judicial intervention as an attempt to impose regulations. Attempts of this type do not constitute a land use regulation and are not violative of Chapter 245, and there's no case that says so.
Counsel, Mr. Hyde, I've got a question
Yes,
for you. Your brief, you talk about development agreements constitute purposes or constitute permits in some cases, and then you say in other cases they're permits, but the permits don't fall under Chapter 245. I was trying to understand what you meant by that. Are you saying that it just doesn't fall under Chapter 245, or are you saying that there's an exception to Chapter 245 that it falls into?
Well, it could be both, Your Honor. If it falls, you know, the double negative is always kind of hard on, I think, a subsection 3 with regard to those exceptions. But or if you look carefully at the development agreement language, a development agreement can have 9 different categories of information, only one of which is a land use regulation. And the rest of it is, and it's funny because the 9th item under 271-152 says any other lawful provision which is appropriate to the parties. And so really it can have an infinite number of different provisions. And here, you know, it's our position that an easement is not a land use regulation on the developer. And the construction of the drainage way is not an imposition that the city is doing by a land use regulation on the developer. The land use regulation, as shown in our brief, is the 2007 requirement to take care of your floodwaters so that you don't flood your neighbors. And for some reason, they feel that that's a requirement that they don't have to follow, and they want to blame the city on it and try to do kind of a bootstrapped allegation that it's the city's responsibility, and then ultimately seek damages. And that's why we think that the deck action is inappropriate. It's just it's a subject matter jurisdiction issue because they're bringing a contract claim and disguised as a deck action.
And the basis of their contract claim, I guess, in your view, is some type of submission made by their predecessor in interest?
Well, you know, obviously, I mean, this agreement was entered into in 2007, and the improvement of the property that is uncontested was done in 2008. Okay. And so they didn't even buy the property until 2012, and then this controversy began in 2017. And so we're talking about almost 15 years ago with regards to the work. And while I've been their city attorney for a decade, I wasn't there 15 years ago, and maybe it wouldn't have been this way if I did it, because the agreement is significantly absent with specificity. I mean, if you look at the requirements in the agreement, it says that we have to build a detention pond. We built a detention pond. It doesn't have any specifications. It doesn't have any requirements, any capacities, any performance standards, and the same thing with the easement. The actual development agreement just delegates all that stuff to the city. It says just, you know, whatever your plans say, do it, and that's it. And we did it. And so there's no evidence in this record that shows that that there was a breach of any of those contractual requirements. And I was going to go through those in my argument, Your Honor, because everything that the contract actually requires, without reading into the contract and expanding it by conflating materials has been performed, and the only land use issue that has even been challenged has to do with the no rise, and we've identified by statute in 2007 the no rise requirement that was there. So whether they're vested or not, even if you assume they are vested, the city didn't impose any changed land use regulation on the property. And there's no one.
Yeah, if I could ask another question, you were talking about the pond that you agreed to build and say you built the pond. And I guess my hypothetical question is this: suppose that you didn't build the pond and the other side had to build their own pond. If they had filed a suit for declaratory judgment alleging that you breached the contract because you didn't build the pond and they had to take on expenses to build the pond, would you be characterizing that as a suit for damages, or is that a suit for declaratory relief?
That would be a breach of contract claim if it's brought properly and in the proper timing. Here, 15 years or almost 15 years after the work was done is an inappropriate time, even under limitations. But there are obligations of which the city would have had in that case if a claim was of such arose and if it arose timely. That is not the case before the court. So when you go through the key, I think the fatal flaw that I see is that when I look through the materials and the allegations made by the plaintiff, the allegations do not identify a land use regulation that is imposed on the plaintiff, on the appellee, that causes or creates those types of impositions. There is nothing doing. The only imposition we have is the 2007 stated no rise equivalent language out of the statute, and no rise is kind of a coined term. So
what's it mean?
I'm sorry.
Describe no rise. You said it's
yeah. So when you develop property, there is an amount of water that leaves the undeveloped land during a rainstorm,
right,
and they quantify that. And then through detention ponds and other types of, there's like 5 water quality ponds that were provided in this project alone, that through that use, you need to slow down the additional water that's going to happen because of your impervious cover, because now it's not going to go into the ground, it's going to go flowing down the street. And so you need to capture that and slow it down so that the amount of water that leaves your property after development is the same amount of the volume of water that left it before development, and its flow rate is supposed to be the same. And so by using easements and drainage that could divert it, by using detention and retention ponds, that's the way that you treat water so that you do not create any more impounding or diversion of water flow, which is against the water code. Chapter 13 of the water code prohibits any person from doing that on your neighbor. And that's what no rise means, is that you don't increase the amount of water flow that leaves.
Okay.
So when you go through and you identify what are land use regulations, which are the only things that apply to 245, there are no land use regulations that are implicated in the petition. It's an easement, and it's the construction standards which are absent from the development agreement, of which there is a contest, and none of those are land use regulations. So the construction of drainage facilities and the easement itself are not land use regulations, which they can do so. And we believe, Your Honor, that to incorporate easements and drainage facility construction as a land use regulation, and then invert it from an allegation of contract into some type of 245 vested requirement, it requires a legislative amendment to Chapter 245, because there's no reasonable way to reconcile those additional steps or comments that are in that would be required to make 245 act in the way that the appellee is trying to make it act. You know, I want to make a point also that under Superwash versus City of White Settlement, it's a 2006 Supreme Court case, 198 Southwest 3rd, 770.
Is that in your brief, counsel?
I'm sorry, no, it's not, Your Honor.
Could you give that to me again?
Yes, sir. It's 198 Southwest 3rd, 770.
Thank you.
And it's a 2006 Supreme Court case where a building official went out to a property and mistakenly applied the law in that case, and then they came back and they were trying to stop the building official from being able to do that. And the court ruled that when governmental employees are performing governmental functions, estoppel is not available in those cases, because the policy of Texas law is that you have an obligation to know the law already. And the fact that we didn't catch you breaking the law in this instance doesn't give you some kind of immunity from that law. And so there's a lot of argument in the plaintiff's brief or the appellee's brief, which discusses negotiation communications to try to resolve the case, which are out of context, and the planning director's comments that are there. And so the only, respectfully, Your Honor, the only entity that you have binding obligations is a court of law when it comes to the interpretation of law. And so whether or not something is vested, the planning director can have an opinion, even I can have a legal opinion, but my legal opinion isn't the law unless a court says it is. And so those are the types of circumstances that we have here. And so we believe that any of that language in the appellee's brief is irrelevant and should not be considered under Superwash. But when you look into the obligations in the development agreement itself, you know, it doesn't, that lack of specificity for any requirements whatsoever places an allegation of improper construction to not have any foundation in the agreement. And so when the argument here is that an improper construction occurred when there are no standards for the construction in the first place, leaves that claim without the foundation necessary to create a cause of action. Because it's undisputed that the drainage easement was obtained and it was improved and it's a current drainage easement right now, Your Honor. About 6 months ago, right around COVID when it started, it was that drainage easement came up on maintenance and was cleaned. So the requirements in the development agreement were all met. We had to build a drainage easement, we built it. We had to build the detention pond, we built it in Bradford, and those requirements as written in the 2007 agreement were met. Those requirements are not land use development regulations, and therefore 245 is inappropriate. And the exaction claims, you know, it's not reasonable for you to think that you can develop property without having to manage your water flow. I mean, since I've been doing this over 20 years, that's a regular requirement for every land developer to maintain the water flow. And so that unreasonable belief, which is not supported in the document itself, because the document says nothing about any obligation to construct any kind of drainage facility or drainage improvement outside of the easement. The plans themselves will show that there were I think there were 5 or 6 water quality ponds that had to be built in accordance with this project that were clearly outside the easement and clearly the obligation of the developer. And there is nothing in the development agreement that relieves the developer from the 2007 no-rise language that we cited in our brief. And so in this case, we believe that there is no jurisdiction for any of the claims associated with this. It was a valiant attempt, but you can't turn an easement into a land use regulation And then you can't take that land use regulation, even if it was a land use regulation, the language doesn't impose the land use regulation on the plaintiff. So it doesn't work. When you look at it closely, it inverts, it puts everything on its head in order to try to create some type of liability.
Are those what you just argued?
Yes.
Is that the basis, the land use regulations and permits, et cetera, is that the basis for their investment-backed expectation takings claims?
Yeah, my interpretation, yes, my interpretation of their pleadings is that they're saying that they did not expect to have any water drainage obligations associated with this property, and that because now they've discovered that they have $1 million of land use regulations to do, that's the reasonable backed expectation. And we're in a position that if looking at the development agreement, there's nothing in the development agreement that would support that expectation. You know, no reasonable developer could believe that they had no obligation to take property that's in a floodplain and elevate it outside the floodplain by way of an easement, a drainage easement being put in the middle of it. That doesn't solve any of the problems. And then you show on the plans themselves that there are 5 water quality ponds that have to be constructed, which is a drainage piece. It's just not. It's contrary to the undisputed facts in the record of this case. And so that's really the base, Your Honor, is that all of the claims here, if you look at them and you first ask, is this a land use regulation? So is 245 even applicable, regardless of whether it's dormant or active, and you take all those out, there's no other claims in the case.
Okay.
And therefore, I'll yield to the appellee at this time.
Justice Parker, Justice Dawes, any questions?
Nothing.
Thank you.
Thank you.
Thank you, counsel. Ms. Hatchett.
May it please the court.
Counsel.
Justice Quinn, you asked Mr. Hyde what this case is about. And what I believe that's very important, because what I think this case is about is whether my client and other land developers in Texas can rely on city-approved site plans, city-approved development agreements that govern their project, and whether they can hold the city accountable to those approved documents. That's the purpose of Chapter 245. It's reliability, it's stability for land developers in Texas, and that's the purpose of a takings claim. It's accountability. So when the government comes and uses or takes your property, they have to pay just compensation.
Okay,
and so I want to talk about—
excuse me, in your view, what property is being taken? I guess I'd ask you, because I'm from West Texas, rural area. I've never heard of an investment-backed expectations taking or a land use exaction taking. So how is that related to, how are those related to the issues? What are those?
Yes, Your Honor. So here it's interesting. So the land, both the investment-backed takings claim and the exaction takings claim are regulatory takings claims. So both of those are claims based on requirements put on the land developer that we are saying interfere in the investment-backed takings claim arena with their expectations of how they could use that property. Or in the exaction claim, it's a burden that's placed on a piece of property that's disproportionate to the impact of that property. So for the investment-backed takings claim, what supports that here is when my client purchased the property, they expected that they would be able to move forward with the prior approvals on this project and develop the property without having to make improvements to the city's drainage channel and to off-site detention. And so that's why I think the facts are so important here, because the Texas Supreme Court in Mayhew talks about what is investment-backed expectations. Well, that is the historical uses of the property. That is what approvals are already in place for that property. And so I want to talk about those there. Before going back to your question, Justice Quinn, the reason I also talk about land use here is because that's part of the history of this too. Goforth granted an easement to the city as part of this development project. And that piece is also very important to the investment-backed expectation claim. So let me explain. This project originally started to be developed in 2007 by Goforth. And at that time, there were 3 documents that were approved by the city. There was a 2007 site plan, there was a development agreement, and there was a drainage easement agreement. And all 3 of those documents provided that in order for this project to go forward, the landowner was going to be required to grant an easement across the property to the city for drainage improvements. And that was a perpetual easement. That easement is still here today. So when you look at the site plan, as Mr. Hyde talked about, the easement is directly across this property, cuts it in half. You have to have a bridge to get from one side to the other. Now, the property owner did not receive a check for that easement. Instead, what they received was that the city agreed that they would be responsible for drainage improvements on that drainage channel, as well as off-site detention. Now, they did not just agree that they would be responsible for that at that time. They agreed that they would be responsible for it all the way into the future. And I want to read that from the drainage easement agreement. The drainage easement agreement specifically says that this easement is to be used to construct, operate, maintain, replace, upgrade, and repair surface water from the grantor's property. That's Goforth and now my client. It goes on to say, improvement and maintenance of the easement property shall be at the sole expense of the holder of the easement. That is the city. And the city still holds this easement today. Now, importantly, when these documents were executed, Mr. Hyde is correct. The 2004 Unified Development Code did govern this property. And it did provide, just like it does today, that when land developers start developing property, they will have to make an agreement with the city about drainage improvements. But importantly, what the UDC also provided, and what Mr. Hyde leaves out, is this provision. The UDC provided that the city could enter into development agreements with landowners that altered the terms of the typical land use regulations. And in fact, I mean, that's what development agreements are for. And so here's what the UDC said. It said a development agreement will be binding on the city and the developer when fully executed, and will be subject to all of the provisions of Chapter 245 of the Texas Local Government Code. So that was in place in the UDC when these documents were entered into, showing that they are valid and that they are to be protected under Chapter 245 vested rights according to the City of Buda's own Unified Development Code. Now, after this happens in 2009, the prior owner applies for a final plat for this property. The final plat also shows this drainage easement and says in the notes that it's to be maintained by the city. Then my client purchases the property in 2012. Right before my client purchases the property, Goforth, the prior owner, seeks a vested rights determination from the city under Chapter 245. And what they seek a vested rights determination about is the development agreement. It's a provision in the development agreement. There's many. They were seeking a vested rights determination as to zoning in the development agreement. But what the city says in response to that is so important because it establishes, particularly for the purposes of the takings claim, why a subsequent purchaser would believe that they had a right to follow the terms of that development agreement and the drainage easement agreement which accompanied it. So here's what the city said. While the preliminary plan for this property expired on February 7th, 2011, therefore a new preliminary plan will be required and my client did submit a new preliminary plan. The expiration of the plan does not alter your rights under the development agreement. A preliminary plan proposing light industrial use would conform to the rights secured by the development agreement. So the city itself decided that this development agreement secured vested rights. Now, my clients purchased the property in 2012. We submit a new preliminary plan for development. It is consistent with the same project that was started all the way back in 2007. It's just a new property owner. And when we submit our plans, they are denied by the city. And the reason they are denied is because the city says, you now have to be responsible for drainage improvements. You have to get a no-rise certification. And what that means in this instance, and what we've pled, is that that means we are required to go onto the city's drainage easement and improve it, and improve off-site detention. The very things that the development agreement, the drainage easement agreement, and these site plans represented was going to be the city's obligation. And that's because the city was given an easement across this property for that very purpose.
So basically, the argument is the city's not living up to its agreement.
Yes, that's right. And
Is that a breach of contract claim of some sort?
good question. We have not asserted a breach of contract claim because, as Mr. Hyde points out, there are many hurdles to getting past a breach of contract claim here.
So you call it a takings claim.
We have a takings claim and a Chapter 245 claim. And I want to briefly address on the Chapter 245 claim why we have a valid Chapter 245 claim based on the provisions of a development agreement. Section 212.172 of the Local Government Code authorizes agreements to be entered into between cities and landowners providing for land infrastructure, including drainage improvements. That section specifically provides that such an agreement will be a permit under Chapter 245. And the legislative history of that section explains why that's the case. The legislative history says such agreements can provide benefits to both the landowner and the municipality, providing certainty as to the development regulations that will apply to the land. House Bill 1197 authorizes municipalities to enter into such agreements and will provide certainty as to the long-term enforceability and validity of those agreements. So this section allows for these agreements and says they have protections under Chapter 245. Now, Mr. Hyde and the city want to argue that Chapter 245 only freezes in place land use regulations, in their case, the Unified Development Code, and nothing else. That, perhaps when we applied for our preliminary plan in 2007 and we received the permit and the development agreement, that gave us vested rights, but it's not vested rights in those agreements themselves. It's just vested rights in land use regulations.
Okay, Council. Hold on.
Yes. Yes, Your Honor.
What is the order from which the appeal was taken? It's an interlocutory appeal, correct?
Yes, Your Honor.
What is the order in which the interlocutory appeal was taken?
The order from the district court upholds our Chapter 245 claim. It does say that we cannot get specific performance to require the city to go onto its drainage channel and construct improvements, but allows our Chapter 245 claim to proceed. And the order also
and
said
the underlying motion from which the order emanated was a plea to the jurisdiction?
Yes, it was.
Okay. So it's your view that you had this permit and you can enforce that permit, and that's what gave the trial court jurisdiction?
Yes, Your Honor. We believe, particularly at this stage.
And is another argument that the trial court had jurisdiction because you have this takings claim, this land use extraction taking and investment back expectation claim?
Yes, Your Honor.
So you got two grounds for jurisdiction, the permit and the takings claim.
Yes, actually, I would say 3 because there's 2 separate takings claims. The
Do we
exaction,
have to adjudicate the validity of those takings claims in order to determine whether to affirm or reverse?
no. It's quite simple for the exaction takings claim because the only thing that the city challenges on the exaction takings claim is ripeness at this point.
Okay.
And it's been challenged for the first time on appeal. So even if you were to decide that the exaction claim was not ripe, even the city concedes we would have an opportunity to amend.
Assuming you could allege facts that would give jurisdiction.
Yes, Your Honor.
Okay, with regard to the permit aspect of jurisdiction, do we have to adjudicate whether or not you have a permit, or is it enough to look at your petition to determine whether or not you've alleged facts saying you have a permit?
Whether or not we have a permit, I think, is a question of law. And so I think here that if you think there's sufficient facts pled for the trial court to decide that there was a permit, which I think that there is, then I think we've met our pleading burden.
But we don't have to adjudicate whether or not there was a permit, or do we?
If there are fact questions that exist, you would not have to. I don't think that there are fact questions here. I think that it is clear that there are permits here.
Okay.
And on that note, to elaborate on that, the permits at issue here is there's a 2007 preliminary plan that was filed, and Chapter 245 specifically states that preliminary plans and all other development permits for land covered by the preliminary plans are considered collectively to be one in a series of permits for a project. So I think that is very clear. And then likewise, Section 212.172 of the local government code specifically states that agreements for land drainage are permits under Chapter 245. I think where the dispute is not so much whether these are permits or not, but whether we have vested rights in the requirements of the permits, or do we have vested rights only in other land use regulations in effect at that time. And there's actually 2 cases I wanted to point the court to that I think address this. One case is Anderton, which you'll just give me a moment.
Are these in your brief, counsel?
Anderton is actually cited in the city's reply brief and relied on heavily there. It's Anderton versus City of Cedar Hill. It's a Fort Worth Court of Appeals case. In that case, an integral part of the court's reasoning is that a permit that the plaintiff owns does confer vested rights. In that case, there's no dispute that there is a permit covering one lot that the plaintiff owns that allows that land to be used for the sale of gravel. And there's a dispute about whether that can be extended to other lots. But for purposes of our discussion, what's important is that no one disputes, not the court or the parties in that case, that for purposes of that lot, because there's a permit governing it, that the landowner would have vested rights to use that lot for the sale of gravel because they received a permit, which has vested rights under Chapter 245. Similarly, there's another case which is cited in our briefing, Save Our Springs Alliance. It's a 2004 case out of the Austin Court of Appeals. And an integral part of the reasoning in that case is the court finds that a development agreement governing the property is what should be looked to for purposes of Chapter 245 vested rights. The plaintiff in that case was actually wanting to apply an ordinance for purposes of Chapter 245 vested rights. But this development agreement was executed after the ordinance. And so the court says, no, we don't look at the ordinance, we look at the development agreement. That's what confers Chapter 245 vested rights. So I think that, along with the language in Chapter 245, dispels any notion that you cannot rely on permits approved by the government as part of Chapter 245. Another example case is Harper Park 2. That's cited, I think, in both parties' briefing. And that explains what does Chapter 245 do? And it says Chapter 245 triggers rights when that first permit is filed, but it doesn't just stop there. The rights continue on all the way until your project is completed. So that means when you come forward to the city with a new permit, the city is to consider that permit based on all the land use regulations.
Now, so how does this relate to jurisdiction?
Well, Your Honor, the city is arguing that we have failed to plead a valid Chapter 245 claim because we have not pointed to any requirements that have been violated, because they say that the requirements of the development agreement don't govern here, that they can change those requirements, and that's not a violation of Chapter 245.
And your argument is 245 has been violated because you had these land development agreements, which became permits, and they're changing them.
Yes, that is right.
Okay.
Because now the city is saying, in order to get your no rise certification, we're going to have to go into the drainage channel and we're going to have to make improvements, which is contrary to these prior documents.
Was there an equivalent of the no rise certification back in 2007?
Yes, there was. There was. And back at that time, just like it is now, when projects start development, the land developers are to work with the city to figure out what drainage improvements need to be made. But back in 2004, there also is this provision, and in fact, this provision is in the code now, which is that these typical land use regulations can be altered by specific agreements with land developers. And that's what a development agreement is. I mean, it's for mutual benefit between cities and land developers when they want to change those regulations. And they did so here.
What did the 2007 agreement say with regard to the land rise or the rise?
The 2007 development agreement doesn't discuss a no rise certification in the development agreement, but I don't think it has to, because
I thought you just told Justice Doss that it did address it. I guess I'm a little confused now again.
I apologize, Your Honor. The Unified Development Code back in 2004 discusses the no rise certification requirement.
So the 07 agreement didn't.
Correct. The 07 development agreement, drainage easement agreement, the permits don't discuss that. They instead just discuss what drainage improvement requirements are going to be required for the project, and they say they're going to be on the city.
And your argument that somehow the no rise was dispensed with in 2007 via the development agreements?
Yes, Your Honor, because what is required for a no rise certification is basically to bring water off your property. And what the development agreements provided for, again, is that the easement would be used to convey surface water from our property, and that the city would pay for that, and that they would continue to make improvements to that.
Okay. Thank you, counsel. Your time's expired. Justice Parker, do you have any questions?
No questions.
Justice Doss, any questions?
Nothing else. Thanks.
Thank you, Ms. Hatchett.
Thank you, Your Honors.
5 minutes, Mr. High.
Thank you, Your Honor. May it please the court. First of all, I will that you do need to adjudicate whether 245 applies in this case, because an exception to 245 in the subsection 3 has to do with areas that are covered as a floodplain. And the area where this easement is part of improvements in a FEMA dedicated floodplain. And we've asserted that exception to any allegation of vested rights relating to drainage, because that's what the provision applies. And when opposing counsels indicate the city was willing to believe, or the city wants you to think, with regards to the limitation of 245 to land use regulations, it's the city quoting the statute. It's not, it's the actual words in the statute that specifically say land use regulation is the only thing that you get vested in. Now, development agreements, as I've mentioned before, have a number of different provisions that can go in them, including anything that's lawful that the people feel is appropriate. I'm stating that because everything in a development agreement is not a land use development regulation. But as in this one, there are some land use regulations that are in the development agreement. For instance, the setbacks the setback requirements for buildings and so forth is in the development agreement that says that if we change the setbacks, they get to use the setbacks that were in place in 2007. There are provisions in there for water and wastewater delivery, which they didn't also, that we exchanged this to, one of the reasons why development agreements come in is that people want to outside of the city limits, they want to hook up for water and wastewater services. And that was part of this deal too. And there were 3 things regarding impervious cover and other things that had to be done to certain lots within the property in order to hook up to water and wastewater. So
Council,
those regulations.
Council, do you agree or disagree that the city of Buda received an easement?
I agree.
And what was okay, received an easement. What was the consideration for the easement? It was a negotiated easement, I guess.
The negotiated easement provided for the water and wastewater services and to manage and control the, I need my glasses, the various land use outside in the ETJ. So it's a written contract. We guaranteed the continuation of the extraterritorial jurisdiction.
Okay, but the consideration for the easement was what? The city was supposed to take care of the costs for doing that drainage?
The city was to build a drainage easement.
Was to build a drainage easement.
I mean, I'm sorry, a drainage way in the easement.
Okay.
And it did that.
Your argument, and they did that. And your argument is that does not encompass any no-rise issues.
That's correct. And when you look at the agreement, it discusses how that the property needed fill. And in order to, and they said everything you dig out of the easement, you can put it there to help us get up and get closer to a no rise, above the floodplain. But there's no obligations whatsoever that say that we are required to place fill in the property in order to get it above the floodplain, or that
in order to resolve this jurisdictional dispute, in your view, do we have to adjudicate the meaning or the scope of what was encompassed within the consideration given for the easement, whether or not the drainage issue includes no rise or not?
I think that that's an issue that may be disputed in the case, because
I understand, but do we need to interpret the agreement with regard to the easement and the consideration and what the parties agreed to back then in order to determine whether or not there's jurisdiction now?
Yes, I think you do. I think if you look at it and you say that there was an obligation of the city to develop it to no rise, well, and actually it matters on how you take the 245 exception, because if you apply the exception that goes to floodplains, which is what we've asserted, then it doesn't matter, because then they don't have vested rights, period.
Okay.
But if you say that the exception doesn't apply, then you would have to determine whether or not there's some type of damage to the remainder of the property by virtue of their exaction claims or their investment-backed expectations for no rise.
And you're saying the no rise certification falls under the federal exception?
No, I'm saying that Chapter 245 has an exception. I think it's like subsection 4 or 5 to drainage facilities that are within a FEMA designated floodplain. And these facilities are within a FEMA designated floodplain, and therefore Chapter 245 does not apply to these drainage facilities because they're specifically accepted by the exceptions in 245.
And that's undisputed, that they are within the FEMA?
Yes, Your Honor.
Whatever.
Yeah, I mean, that's really the whole thing is that the whole, 3/4 of the property is in the floodplain, and they've got to lift it up out of the floodplain to develop it.
Thank you, counsel. Your time has expired. We appreciate it. Justice Parker, do you have any questions?
No questions.
Justice Doss?
I don't have anything.
Counsel, we appreciate you appearing in front of us via Zoom. Hopefully there will be a time in the near future where we can have these arguments in person. And I know I'm hoping for that time. But with that said, your case is submitted and you are excused